Hello, everyone, and welcome to our first session on business law. I am Dr. Cindy Jimenez, and I am thrilled to be guiding you through this course. Together, we will explore how the law shapes the way we conduct business and make decisions in our personal and professional lives. Before we dive into the course, let me tell you a story. A friend of mine once started her own bakery. She poured her heart and soul into it, creating recipes inspired by her grandmother. Everything seemed perfect until one day a customer slipped on a wet floor and sued her for damages. She had no liability insurance, no legal guidance, and almost lost the bakery she worked so hard to build. It was a hard lesson, but one that taught her how important it is to understand the legal framework that surrounds us. Now, think about your own life. Have you ever rented an apartment and signed a lease? Purchased a product online and agreed to the terms and conditions without even reading them? Or even split a bill at a restaurant with friends? Whether we realize it or not, these everyday actions rely on laws to function smoothly, ensuring accountability, fairness, and trust. Throughout this course, we will uncover the principles of business law. We will learn how it's structured in Canada and discover how to navigate it effectively in both personal and professional contexts. By the end, you will have the tools to make informed decisions and become more confident in understanding the legalities of the business world. As this session is recorded, it will be available for you to revisit as many times as you need while the term lasts. If you have questions, I encourage you to post them in the discussion sections of the course shell. Chances are the same questions you have might help another student, and this way we can create a collaborative learning environment. So let's get started with the first key topic: why business law is relevant and essential for everyone. Let's move to the next slide. Let's start by thinking about this. What do you think law is? How would you define it? Is it about fairness, order, morality? Take a moment to reflect and feel free to share your thoughts in the discussion section of the course shell. One of the most well-known definitions of law comes from William Blackstone, who wrote in his commentaries on the laws of England that law is a rule of civil conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. Sounds very straightforward, doesn't it? But here's the catch. What happens when a society changes its mind about what is right and what's wrong? So imagine living in a world where the law required us to burp in public after every meal. Picture restaurants with signs saying burp before leaving, or even funnier, a law mandating mismatched socks on Tuesdays. While it's a silly example, it shows that law doesn't inherently define what's righteous. It's about creating order and reflecting societal norms. The law isn't perfect, and the gap between what's right and what's legal can sometimes feel frustratingly wide. That's where the role of law as a social control comes in. Laws are society's way of maintaining order and ensuring fairness, even if they are not always perfect. They create predictability and stability, which are essential for businesses. For example, without traffic laws, our roads would be chaos. Similarly, in business, laws regulate interactions between companies, employees, customers, and competitors, making the marketplace safe and reliable. Business law is more than just a set of rules. It's the foundation that ensures fairness and accountability in the business world. In Canada, our legal framework is designed to: number one, regulate business activities; number two, protect stakeholders; And number three, maintain order in the marketplace. Why is this important? Imagine a world without business laws, so no consumer protection laws. That means companies could sell faulty products with no consequences. Customers would be left helpless. And for example, no employment standards, so workers could be underpaid or unfairly dismissed, leading to widespread dissatisfaction and instability. These examples highlight how business law safeguards trust, accountability, and fairness in the marketplace. So, modern businesses operate in an incredibly complex legal environment. Laws influence almost every aspect of business operations, such as the formation of business organizations, because understanding partnerships, corporations, and trusts is essential. Then, employee working conditions. So, employment laws protect workers from unfair treatment. Of course, customer and competitor relationships, because consumer protection and competition laws ensure fair practices. Then, acquiring business premises. Land laws regulate leasing, purchasing, and financing locations. Contract law governs agreements like leases, vendor contracts, and client terms. Then, securing debt and credit. Well, laws ensure creditors and borrowers operate in a framework of trust. Of course, don't forget about environmental regulations to protect public health while allowing businesses to operate sustainably. And finally, intellectual property protection that safeguards business innovations and ideas. There are two critical areas of business law. The first one is tort law, and the second is contract law. So, tort law. This area addresses injury to others. Imagine a customer sleeps on a wet floor in a store and sustains an injury. Without clear liability insurance or legal guidance, the store owner could face significant penalties. Tort law helps ensure fairness and accountability. And then, of course, we have contract law. Contracts govern most business interactions. For instance, if you lease office space, the lease is a contract that outlines obligations like rent payments and maintenance. If one party breaches a contract, remedies are available under contract law to resolve the dispute. Now, let's clarify some important concepts. So, let's talk about the difference between rights and privileges. Rights are inherent, like freedom of expression or owning property. But privileges are granted by law, so they can be revoked, such as operating a business or even driving a car. So, understanding this distinction helps us see how the legal framework supports fairness while imposing accountability. But here's the exciting part. Business law isn't just about compliance, it's also about opportunity. When you understand the legal landscape, you are better equipped to identify growth opportunities and minimize risks. For example, knowing intellectual property laws can help protect your ideas and innovations, giving you a competitive edge. Understanding contract law can help you negotiate stronger agreements with partners and clients. Staying informed about evolving laws like those governing e-commerce or cybersecurity ensures you're ahead of the curve in a dynamic environment. Think about your own experiences. Have you encountered a situation where a business followed or broke the law? How did that impact your perception of the company? Or maybe consider this. Have you ever found yourself in a situation where understanding the law could have made all the difference? Share your thoughts in the discussion sections again. By understanding how business law creates both challenges and opportunities, you'll be better prepared to navigate this complex environment. Next, let's discuss how to become a sophisticated client, someone who works confidently with legal professionals. Let's move to the next slide. Before we dive into what it means to be a sophisticated client, let me share a quick story. A friend of mine, let's call him Dave, decided to open a food truck. He was excited, ambitious, and ready to conquer the street food scene. Dave figured he would save some money and handle all the legal stuff himself. After all, how hard could it be? He Googled some templates, copied and pasted a contract for a supplier, and skipped reading the fine print on his checklist agreement because who has time for that, right? Fast forward a few months. Dave's supplier stopped delivering on time because his contract didn't include a penalty for late deliveries. Then he discovered his lease agreement had a clause that allowed the landlord to raise the rent by 20% after 6 months. Poor Dave. He ended up with a food truck that was barely breaking even and a headache he couldn't avoid it by being a bit more, let's say, sophisticated in handling his legal affairs. Now, Dave isn't alone in this. Many people approach legal situations without enough knowledge or preparation. And that's where the idea of becoming a sophisticated client comes in. The goal of this course is to help you avoid Dave's mistakes and approach legal matters with confidence, clarity, and strategy. So, what exactly is a sophisticated client? Well, it's someone who, first, understands the basics of law and how it impacts their decisions. Second, knows when to call in the experts because Google can only take you so far. Third, asks the right questions and evaluates legal advice critically. Four, makes informed decisions to protect their interests and maximize opportunities. This course is your chance to build those skills and become the kind of client lawyers love working with, someone who is informed, proactive, and confident. By the end of this term, you will know how to navigate contracts, address disputes, and even understand when to push back or ask for a second opinion. Let's make this more interactive. Think about a time when you had to deal with a legal document or a tricky situation, maybe signing a lease, returning a product, or resolving a dispute. How confident were you in handling it? What do you wish you had known then that you know now? Share your thoughts again in the discussion section. Now that we have introduced the idea of becoming a sophisticated client, let's break down the specific traits that define one. These are the building blocks we will focus on throughout this course. Let's move to the next slide. Now that we have set a foundation for what it means to be a sophisticated client, let's take a closer look at the specific traits that define one. Think of it like this. Imagine you're building a house. Each of these traits is a brick in the foundation, helping you construct a strong and stable structure to support your legal and business decisions. So the first one is understands the role of the lawyer and client. First, a sophisticated client knows that lawyers are not magicians who solve all your problems while you sit back and relax. Instead, it's a partnership. Lawyers provide expertise, options, and advice, but the ultimate decisions are yours to make. For example, if a lawyer recommends settling a contract dispute instead of going to court, it's up to you to weigh the risks and decide what's best for your business. A sophisticated client doesn't blindly accept advice. They ask questions and ensure they fully understand the implications. Then, a sophisticated client understands the significance of law in business. The second trait is recognizing that legal issues aren't isolated. They are woven into the fabric of every business decision. From hiring employees to signing contracts, the law is always present. For instance, did you know that a poorly worded clause in an employee contract could lead to years of disputes? Or that failing to understand tax laws could result in penalties that cripple your cash flow? Sophisticated clients see the bigger picture and use the law to protect and grow their businesses. Then a sophisticated client knows when to hire a lawyer. Not every situation requires a lawyer. A sophisticated client knows the difference between what they can handle themselves, like simply day-to-day tasks, and what requires professional expertise. For example, setting up a business. Hire a lawyer to choose the right structure and ensure compliance. Reviewing a complex list? A lawyer can identify hidden clauses that might cause trouble later. Knowing when to call in legal help saves you time, money, and potential headaches. A sophisticated client understands the costs of hiring a lawyer. Legal services can be very expensive, and a sophisticated client is always prepared. Lawyers charge in different ways: fixed fees, hourly rates, or contingency fees. Understanding these options allows you to budget effectively. Imagine this. You need a lawyer to draft a partnership agreement. A sophisticated client would ask upfront, what's the total cost? Or are there any additional fees I should be aware of? This ensures that there are no surprises when the invoice arrives. Then, a sophisticated client knows how to file a complaint about a lawyer. Let's be honest, not every lawyer will meet your expectations. Maybe they didn't communicate well, or you felt they didn't act in your best interests. A sophisticated client knows how to hold lawyers accountable by filing a complaint with the appropriate law society. This ensures professional standards are upheld and protect all the clients in the future. It's not about being confrontational. It's about advocating for yourself and ensuring fairness. And finally, has a general understanding of business law. A sophisticated client understands the basics of business law. This doesn't mean you need to memorize statutes, but you should know enough to ask the right questions and spot potential issues. For example, if you are reviewing a vendor contract and notice a vague clause about penalties for late payments, you will know to flag it and seek clarification. This basic knowledge is your first line of defense in avoiding legal troubles. Let's make this personal. Think about these traits, the ones that we had mentioned before. Are there any that you feel confident in already? Maybe you're good at budgeting for legal services, or perhaps you're skilled at asking questions. Which traits do you think you will need to work on the most? Share your thoughts. Throughout this course, we will work on developing these traits together. By the end, you will not only understand the legal landscape, but also have the tools to navigate it like a pro. Becoming a sophisticated client isn't just about legal matters. It's a mindset that will serve you in every aspect of your career. Now that we have covered the traits of a sophisticated client, let's explore the legal systems that underpin business law in Canada. Understanding these systems is the first step in navigating the legal framework effectively. So let's move to the next slide. To understand where our legal systems come from, let's start by asking, why do we need laws in the first place? Imagine living in a time when there were no written rules, no courts, and no enforcement mechanisms, only agreements made by word of mouth and trust. As societies became more complex, so did the need for systems to resolve disputes and maintain order. The story of law begins in the early civilizations. In these ancient societies, laws weren't written down. They were passed orally from one generation to the next. These oral traditions govern everything: trade agreements, disputes over land, and even personal relationships. While we have come a long way since then, we can still see traces of this method today. Think about when a witness give testimony in court on their oath. Their spoken word carries legal weight, much like in ancient times when verbal agreements were considered binding and sacred. Initially, laws often began within the family. Parents and elders determined rules for inheritance, marriage, and discipline. These family-based laws expanded as communities grew larger. Leaders created more formal rules to govern disputes between families and individuals. As societies became more organized, these rules formed the foundation of what we now recognize as legal systems. With the rise of city-states, the need for written laws emerged. A famous example is a Code of Hammurabi, written in ancient Babylon around 1754 before Christ. This code outlined rules for contracts, labor, and property disputes. It also established penalties such as a well-known principle of an eye for an eye. However, it is important to note that these early laws often reflected the interests of the ruling elite. For example, penalties for harming a slave were far less severe than for harming a free person. This imbalance of power is something we continue to see in many legal systems, even today. As societies evolved, customary law emerged. These laws weren't written, but were based on long-standing practices and traditions that were widely accepted by the community. Customary law governed everything from property rights to trade and conflict resolution. Interestingly, this type of law is still very much alive. In Canada, Indigenous communities continue to rely on customary law, rooted in their cultural values and traditions. For instance, many Indigenous groups prioritize restorative justice, focusing on healing and community well-being rather than punishment. Before the Norman conquest of England in the year 1066, England's legal system was decentralized and based on local customs. Justice varied widely depending on the region, and disputes were often resolved by local leaders using informal rules. However, this changed significantly with the Norman conquest. William the Conqueror centralized legal authority, marking the beginning of the common law system. Under Norman England, judges began traveling across the country to resolve disputes. They relied on precedents, decisions made in earlier cases, to ensure consistency in their rulings. This was the birth of common law. At the core of this system is a principle of stare decisis, which means to stand by things decided. In other words, once a court has ruled on a matter, future courts are expected to follow that precedent in similar cases. For example, if a court decides that employers must provide safety equipment for workers, future courts will apply that same principle when similar disputes arise. Stare decisis ensures consistency, predictability, and fairness in the legal system, but it also allows the law to adapt to new challenges over time. While common law relies on judicial decisions, statute law consists of written laws created by legislatures. These laws are specific and clear, addressing issues such as taxation, workplace safety, and environmental protection. In Canada, statute law works hand in hand with common law. Courts interpret and apply statutes to individual cases, creating a dynamic and evolving legal framework. In contrast to common law, civil law is codified. Judges in civil law systems apply comprehensive written codes to cases rather than relying on past decisions. This system is predominant in countries like France and Germany, as well as in Quebec here in Canada. In fact, Canada's legal system is unique because it incorporates both common law and civil law. While most provinces follow common law, Quebec applies civil law for private matters like contracts and property disputes. It's also important to recognize the foundational role of Aboriginal and Indigenous law in Canada. Long before colonization, Indigenous peoples had their own sophisticated legal systems. These systems were deeply rooted in oral traditions, spiritual beliefs, and respect for the land. They governed relationships within communities and with nature, emphasizing harmony and sustainability. Today, Indigenous law continues to play a vital role in Canada's legal landscape. For example, the Haida Nation uses traditional laws to manage natural resources, ensuring sustainability for future generations. Indigenous courts often focus on restorative justice, aiming to repair harm and restore community balance rather than simply punishing offenders. Canada's government has a legal obligation to respect and uphold Indigenous laws under treaties and agreements. However, this recognition hasn't always been seamless. Disputes often arise when Indigenous legal principles conflict with federal or provincial laws. Acknowledging and integrating Indigenous law is a critical step toward reconciliation. Finally, let's reflect on the idea that law, at its core, comes from conventions, meaning agreements, made by society. But we must also remember that these conventions are often shaped by those in power. In early civilizations, laws like the Code of Hammurabi prioritized the interests of the ruling class. In modern times, we see similar dynamics in areas like environmental regulation, where corporate lobbying influences policy to favor business interests. These examples remind us that laws aren't always neutral. They reflect the values and power structures of the societies that create them. So let me leave you with this question. How do you see societal conventions and power dynamics shaping the laws we follow today? Can you think of examples where laws seem biased or reflect an imbalance of power? Let's reflect on that as we move to the next slide, where we will take a global perspective and explore the distribution of legal systems around the world. So now that we have explored the origins and evolution of legal systems, let's take a step back and look at the big picture. How are these systems distributed around the world, and what does that mean for businesses and societies? This slide gives us global perspective, showing how different regions operate under distinct legal frameworks. So the map illustrates the dominance of two major legal systems, the civil law system and the common law system, but it also highlights other systems like mixed, customary, and even the Sharia law. Let's start by breaking this down. First, notice the areas in blue. These represent countries that follow the civil law system. This system is prevalent across continental Europe, much of Latin America like Mexico, and large parts of Asia and Africa. Civil law is based on comprehensive written codes and statutes. Judges in these regions focus on applying these codes to cases rather than interpreting past decisions. For example, in France, if a dispute arises about a contract, a judge will refer to the civil code for clear, predetermined answers. Now, let's look at the areas in red, which represent a common law system. Common law is used in countries like Canada, outside of Quebec, the United States, Australia, and the United Kingdom. As we discussed earlier, this system relies heavily on judicial precedents. Judges play a key role in shaping the law by making decisions that future courts follow. For example, a US court ruling on data privacy today could influence similar cases for years to come. This adaptability is one of common law's greatest strengths. Then we have the areas in yellow, which indicate mixed or bijuridical systems. These countries combine elements of both common law and civil law. Canada is a prime example, as Quebec uses the civil law system for private matters, while the rest of the country follows common law. Businesses operating across provincial lines most understand this dual framework to navigate contracts and disputes effectively. Then, the brown regions represent customary law, which is rooted in traditional practices and cultural norms. In many African countries, for instance, customary law governs issues like marriage, inheritance, and land use. While these laws may not be codified, they are deeply respected within the communities they serve. Customary law is also significant in Canada, where Indigenous communities rely on their own legal traditions to address governance, resource management, and conflict resolution. Finally, there are areas that highlight countries where Sharia law, based on Islamic principles, plays a significant role in the legal system. Sharia law governs many aspects of personal, family, and financial matters in these regions. For example, in Saudi Arabia, business transactions most align with Islamic principles, such as avoiding interest-based loans. Now, why does this global distribution matter? For one, understanding the legal framework of a country is critical for businesses operating internationally. Let me give you an example. Imagine you are negotiating a business deal in Germany, which follows a civil law system. Your agreement will need to align closely with written statutes, leaving little room for interpretation. On the other hand, if you're handling a dispute in the United Kingdom, a common law country, the outcome could depend heavily on past judicial decisions. Another example, suppose you are expanding your business into a country that incorporates Sharia law. You would need to adapt your financial practices to comply with Islamic principles, such as avoiding transactions that involve interest. Without understanding these legal nuances, your business could face significant challenges. This map also reminds us of the historical and cultural influences that shape legal systems. Each system reflects the unique values, priorities, and power structures of the societies that created them. For instance, civil law systems prioritize structure and predictability, while common law systems emphasize flexibility and adaptability. But beyond these systems, we must also consider Indigenous laws, particularly here in Canada. As we discussed earlier, Indigenous laws are deeply rooted in tradition and play a vital role in many communities. They remind us that law isn't just about formal systems, it's also about respecting cultural values and traditions. The Canadian government has a legal and moral obligation to uphold Indigenous laws as outlined in treaties and agreements. However, the challenge lies in harmonizing these laws with federal and provincial systems, which often leads to conflict. So let me ask you this. Looking at this map, how do you think legal systems influence international business, diplomacy, or even everyday life? Can you think of any challenges that might arise when different systems interact? For example, how might a dispute between a Canadian company and a French company be resolved when one relies on common law and the other one on civil law? Take a moment to reflect on these questions and feel free to share your thoughts. Understanding the global distribution of legal systems is crucial, not just for navigating international business, but also for appreciating the diversity and complexity of justice around the world. As we move forward, we will discuss on how these systems interact with modern business practices and what that means for you as future leaders. Let's move to the next slide. In Canada, our legal system is built on two primary sources. First, statutes or legislative law, and case law or judge-made law. Together, they create a comprehensive framework that governs business operations, protects individual rights, and ensures fairness in society. But at the heart of all Canadian laws lies a greater foundation, the Canadian Constitution. It's the supreme law of the land, providing the legal framework for governance and guaranteeing fundamental rights and freedoms for all Canadians. Before we dive further into statutes and case law, let's explore the Constitution, the Canadian Charter of Rights and Freedoms, and how these guide and shape the application of law in Canada.